is very common to think of the two-element doctrine of customary international law as being grounded in Article 38, itself a manifestation of customary international law. Well, by virtue of the suspension of the belief system, which this book invites the reader to conduct, you will no longer see the two-element doctrine of customary international law as being derived from Article 38 and possibly the corresponding customary international legal rule. No, rather, the two-element doctrine of customary international law becomes the result of an intervention of a very specific actor, namely the Permanent Court of International Justice in the 1920s, which imposed upon international lawyers a specific way to speak about customary international law. Article 38 is not the seat of the two-element doctrine. Article 38 does not distinguish between the two elements. The two elements were distinguished in the case law of the Permanent Court of International Justice. Article 38 being the product of its time, that is a time where we didn't clearly distinguish between the two elements. The suspension of the belief system, which is proposed by this book, will lead colleagues and peers, at least I hope, to realize how much our main doctrines have been artificially derived from a few carefully selected international instruments. The same holds with the doctrine of statehood and the Montevideo Convention on the Rights and Duties of States. The doctrine of statehood boils down to a set of modes of legal reasoning about subjectivity, which was designed and refined in the 50s and 60s. When that doctrine was designed and in the 50s and 60s, and mostly in the 60s, that is at the time where the world was changing because of decolonization and the arrival of a huge number of new states, international lawyers felt the need to put forward a rigid doctrine of statehood. But they needed as well to anchor these new doctrines, which they think or they thought would help them manage the birth of new entities in the international society. They needed that doctrine to be anchored in an international instrument. And the only international instrument they could find at the time was the Montevideo Convention on the Rights and Duties of States, which is a convention that had been for decades completely overlooked, not only because of the low number of ratification, but also because the Montevideo Convention was not meant to codify universal international law. It was meant to codify the law of the Americas with a great emphasis on non-intervention. It was not meant to be the nest of the doctrine of statehood. I don't even think that the Montevideo Convention has anything to do with statehood. Its famous or infamous Article 1 and the definition of state is only of a definitional nature. There is no norm. However, this was found at the time in the 60s as a useful repository for this newly created doctrine of statehood. Realizing how much we have created an artificial link between our key doctrines and some international instrument is the main ambition of this book. This book is an invitation for more self-reflectivity extended to all international lawyers, students, researchers, legal counsels, legal advisors, practitioners.